am grateful for the opportunity to testify regarding HB 1957, a bill which proposes an amendment to the Constitution of the Commonwealth of Pennsylvania providing for personal reproductive liberty. The aim of my longer written testimony, which I submitted, is to provide a scholarly legal analysis of HB 1957, and I urge you to read it in its entirety. But what I would like you to come away with are these few things. First, that the predictable and likely effect of this amendment will be to invalidate existing Pennsylvania law with respect to abortion specifically, but reproduction more generally, and deter the enactment of future common sense legislation. Second, that the amendment's undefined terms, individual and reproductive liberty, suggest it will be applied to persons and situations far beyond women seeking abortion. And third, that the likely impact of the amendment's non-discrimination clause will be that all such services, not just abortion, will be paid for by the taxpayer. Before I explain those concerns with the amendment, I want to point out a kind of special concern, I think, for you as legislators regarding this amendment. And this is that if the 50 years between Roe and Dobbs taught us anything, it was that enshrining abortion access in the Constitution did not bring civic peace on this question. So whatever your view on abortion policy, Dobbs was meant to allow states, the people, through their legislatures, you, to enact laws that reflect their complicated views on these difficult questions. And the legislative process is the way that Americans work through these fraught questions and come up with solutions, sometimes compromises, that work in a diverse and pluralistic society. I know you know this is your job, but on the other hand, constitutions are generally more suited to laying out the conditions or the frameworks of government, right? And they don't lend themselves to resolving difficult policy questions. So the effect of this amendment that I'm going to describe would shackle you, the legislature, and prevent the people of the Commonwealth from expressing important state interests or providing guardrails, even minimal ones, in an ethically sensitive area where women can be coerced. So again, even if you're pro-choice, this amendment ties the hands of you, the legislature, to safeguard against abuse, to preserve informed consent, to be responsive to whatever might come down the line in terms of scientific developments or medical discoveries, et cetera. So this amendment, should you pass it, would be a sort of abdication of your lawmaking authority to the judiciary, right, to fashion policy on a matter that's deeply relevant to important state interests and to the protection of the common good. Okay, so to the likely effect of the amendment. I don't think that most advocates of the amendment are transparent about what effect it will have. Many proponents say things like this kind of amendment will just restore Roe or protect our existing laws, and those things have purchase with most people who aren't steeped in the jurisprudence of abortion, and I think those euphemisms are misleading. So what would the amendment do? First, it will not protect your existing laws. It will be the occasion for striking them down. The language of the amendment states that the Commonwealth may not deny the fundamental right unless justified by a compelling state interest achieved by the least restrictive means. This technical legal language is known among lawyers as strict scrutiny, and if adopted, every law relating to reproductive liberties would be subjected to this intense scrutiny. And it's such a high bar that colloquially it's referred to as strict in theory, fatal in fact, meaning that very few laws survive challenge under this rigorous test. And we know this because we can look to both federal law and state law to see how this plays out. When the Supreme Court first adopted or identified the federal constitutional right to abortion in Roe, it at first adopted this same test, strict scrutiny. And in the years following Roe, courts invalidated nearly every law that came before it because of this very high standard. Now, as Pennsylvanians, I think, likely well know, or at least Pennsylvania lawyers likely well know, when the court revisited Roe in Casey, right, it affirmed, of course, the constitutional right to abortion, but it took a look at the strict scrutiny standard and it said, you know, that's actually too strict. It doesn't allow the state to advance certain interests that it has that are legitimate, that really don't bear on the woman's ultimate right to choose abortion. And so the Casey court got rid of strict scrutiny and adopted a different standard called undue burden. But we can look to those pre-Casey cases and see what strict scrutiny does. We can also see in states that have adopted strict scrutiny in interpreting their own state constitution, as you're seeking to do through this amendment. And it's the beginning of a long line of cases striking down the laws on their books. My written testimony refers to dozens of instances of this happening at the state level, but I want to point you in particular to the recent examples just in the last couple of years. So Arizona, Michigan, Missouri, Ohio, they all passed amendments like the one similar, different in an important respect I'll mention in a minute. But they all adopted amendments incorporating strict scrutiny, and all of them are embroiled in litigation defending their state laws, many of which have now been enjoined. So at a minimum, under the strict scrutiny test, your existing laws will be subject to extensive, expensive litigation that the state will be involved in. Second, there's little reason to trust your laws will fare any better, right, than all of these other laws. And so even your laws that have broad public support, like parental involvement or the 24-hour waiting period or late-term restrictions, right? Those are all vulnerable under this standard. And then every future law that you might think might be a good idea as you want to be responsive to changing circumstances will be immediately subject to the criticism, you know, this is going to be subject to strict scrutiny in the courts. This is a waste of our legislative resources to even try to address this problem. So second, the amendment will not restore Roe because it goes far beyond even what Roe did. And this is why. Because in Roe and in Casey, regardless of whether they adopted strict scrutiny or undue burden to examine laws, both cases provided a kind of sliding scale. For Roe, it was the trimester framework. For Casey, it was viability. But to recognize the nature of the state's interests grew, became more compelling, became more important as the pregnancy progressed. And so both cases allowed, written by people who supported the right to abortion, right? So both cases acknowledged that states should have more latitude in restricting abortion after viability. HB 1957 makes no such allowance. Moreover, this amendment would make you an outlier even among your sister states. So the amendments I previously mentioned, Arizona, Michigan, Missouri, Montana, Nevada, Ohio, all of them recognized this, had a viability framework built into those amendments. HB 1957 makes no such allowance. So strict scrutiny will apply in Pennsylvania to any law touching on abortion throughout the entire pregnancy, from conception past viability to the delivery room, past your current 24-week gestational limit, meaning that post-viability regulation or even born alive protections are vulnerable under this amendment. Another way in which this amendment goes beyond Roe is its scope, that is, who it protects and what it protects. So first, who it protects is individuals, and the word individual is not defined. So it raises interpretive questions. Some court is going to have to deal with the question of who this statute protects. And the plain text makes no distinction between adults and minors. Now, numerous courts, including the Supreme Court, have held that while minors may have constitutional rights, they're different from adults because children are immature, they're vulnerable, and of course we have the presence of the fundamental rights of the parents, right, to be involved in the decision-making and care and custody of their children. But the plain meaning of this amendment contains no reference to the unique status of children and contains no limitations. So it suggests that Pennsylvania courts may grant an absolute right to abortion or any other reproductive decision, such as sterilizations, to children under this amendment, which substantially weakens the Commonwealth's interest in both protecting parental rights, but also protecting minors from things like reproductive coercion, sex trafficking, et cetera. Another interpretive question in terms of the scope is the phrase reproductive liberty. So this isn't just about abortion, right? The amendment provides a kind of non-exhaustive list of things, including abortion, which this amendment is intended to protect. And so reproductive liberty could be interpreted to include decisions regarding many other matters, which similarly would be removed from the province of the legislature to really shape and to respond to the needs of citizens. Okay, a final point is that it is predictable and likely that the non-discrimination clause in the proposed amendment will lead to constitutionally required taxpayer funding, not only of abortion, which admittedly your Supreme Court has already telegraphed that it will require, but because of this broad scope of what the amendment purports to protect, reproductive liberties writ large, any services or procedures or resources determined to be protected by the fundamental right to liberty will likely be required to be paid for by the taxpayer. I suspect, like all governments and all household budgets, you have many demands and needs that you seek to meet in your day-to-day work. And this amendment will get you further into the business of funding every procedure, every service, every medication related to reproduction. And again, we know this because we can look at case law from other jurisdictions that have adopted strict scrutiny. With only one exception, every state court that recognized an independent right to abortion, an independent state right to abortion, and that adopted strict scrutiny has struck down limits on taxpayer funding of abortion on non-discrimination grounds. So in conclusion, the proposed amendment adopts a standard of review, strict scrutiny, with no limiting framework like viability that is so protective of abortion and any other decision that would be deemed to fall within reproductive liberty, that it is virtually certain to both strike down existing Pennsylvania law and to discourage future common sense laws. And I think legislators who support this amendment must admit that they support those things, that they support relinquishing lawmaking with respect to grave matters like permitting unrestricted abortion throughout pregnancy, even of healthy, viable infants, or that they support allowing minor girls to get abortions or sterilizations or other reproductive treatments without their parents' knowledge, support, or consent, and that they support all of these things being paid for by the taxpayer, because that is what the clear consequence of this amendment is, according to the overwhelming weight of precedent from other states and from pre-Casey federal law. So again, I urge you to read my written testimony in its entirety, and I'm grateful for the opportunity to contribute to this discussion on this important question.